Hi, my name's Sarah Einowski, and I'm an estate planning attorney at Tonkin Torp, a Portland-based business law firm. I'm licensed in Oregon and Washington and here to help with any of your estate planning needs. Today, I'm here to talk about the basics of any estate plan. So the basics are going to be three key documents: a will, a power of attorney, and an advance directive, or in some states called a healthcare power of attorney. The will is what happens to your stuff and your minor children on your death. Now, you may think if you're a single person, you don't have an estate to think of, that you may not need a will. But the thing is, everyone has an estate plan, whether you write it down or not. If you don't write it down, it's whatever the state tells you it is. So if you're a single person and your parents are still living, they are your heirs at law. So they will get your assets in the event of your death. If your parents aren't living and you have siblings, your siblings will get your assets. So that may be how you want your assets to go, but if you don't, then it's a good thing to write it down and work with an attorney to formulate your will. If you have minor children, it can be just as important to create a will in order to best set up your children for success in the event that the worst should happen. That's the thing to keep in mind. These documents only matter if something horrible has happened, if the worst has happened, the thing we don't want to think about. And we want to set up you and your loved ones and your estate for the best success. So if you have minor children, a will can do two important things. One, you can nominate who's going to take care of your children in the event that you and the other child's parent is gone, whether it's your spouse or your co-parent. And you can dictate how old your child will be in the event, how old your child will be when they inherit your assets. So let's say, for example, we have spouses that have $1 million each of life insurance on the two of them. There's a horrible car accident. Parents are gone, child survives. If you're in Oregon, Oregon will say that as soon as the child reaches 18, they're an adult and they're able to take the assets free of trust and free outright. So if you have $1 million each of life insurance, that's $2 million that you're handing an 18-year-old who has lost their parents. Typically not a great idea. So what a will lets you do is create what we call a testamentary trust, where the assets can be put in trust for the benefit of your children. And that way the assets are there for their benefit to spend on college, to down payment on a house, to start a business, the things you would normally be helping your child with if you were still around. But while it's in trust, it's got creditor protection. So the most common creditor of a young adult is a bad first marriage. So if your child gets divorced while the assets are in trust, they're protected from the ex-spouse. It also protects the child from themselves, from making bad decisions and going out and buying 10 Ferraris instead of maybe investing in college. So that's the benefit, can be some of the benefits of creating a will. The other two documents that are the foundation for any estate plan are disability planning documents. So this means you're still alive, but something's happened to you and you're unable to manage your own financial and legal affairs or make your own medical decisions. Many people assume that because they're married, their spouse can make these decisions for them automatically, but that's not necessarily the case. If you don't have these documents executed and you are unable to make these decisions for you, and some third party, some bank, some doctor, some whatever doesn't think your spouse has authority, your spouse is going to have to go to court and get appointed as conservator to handle your financial or legal affairs, or get appointed as guardian to make medical decisions for you. To avoid that hassle and expense when clearly something horrible has happened, it's best to make these documents ahead of time. So a power of attorney is where you name an agent to make legal decisions for you, legal and financial decisions for you if you're unable to. For married couples, we typically name the spouse as the first agent, and then it's good to have a secondary agent to make those decisions if you and your spouse are unable to. For example, if the two of you are in a car accident, you're both in the coma, who's going to take care of you in that instance? The second document is, in Oregon, it's called an advance directive. In other states, it's called a healthcare power of attorney. And in this document, you name somebody to make medical decisions for you. Again, for married couples, we typically name the spouses first, and then it's good to decide who your secondary and maybe even third agent is going to be in the event your spouse is unable to make those decisions for you. It's always good to have a thoughtful discussion about who these agents are going to be, the emotional impact it may have on you, your family, and your agents that you're naming, and have a thoughtful and thorough plan for your estate and disability planning needs. If you have any other questions about estate planning and your estate planning needs, please feel free to reach out to any of us at Tonkin Torp or me directly. My information's there on the screen, and I look forward to hearing from you soon.